Welcome. Good morning. Seated here are some of the distinguished leaders who work in the office of the Attorney General, also known as the Department of Justice. They are here because these are the professional leaders who have made and make recommendations to me related to issues surrounding employment matters, civil litigation, the releasing of public records, and human resources as it pertains to this office. So before we go any further, I would like to turn the microphone over to these leaders for the purpose of an introduction. Sonia.
Hi, I'm Sonia Mallett, and I'm the Director of the Litigation Division of the Louisiana Department of Justice. I began my legal career under Attorney General Gust in 1991 as a staff attorney. I was appointed the Director of the Litigation Division in 2012 by A.G. Caldwell, and I remain in that position today under Attorney General Landry.
My name is Alicia Wheeler. I'm an Assistant Attorney General Specialist in the Civil Division. I'm working with public records. I've been with the Attorney General's office since 2017.
Hello, my name is Angelique Friel. I'm currently the Director of the Civil Division. I've had the pleasure to serve under 3 Attorney Generals. I began working here in 2007 as an attorney in the education section of the Civil Division. I ascended up to an education section chief, then a governmental section chief, then a deputy director, and I've had the pleasure to serve as the director for 4 years. Prior to that time, I was in private practice, and right out of law school, I had the wonderful honor of clerking for Judge Jimmy C. Peters of the Third Circuit Court of Appeal.
Hello, my name is Sandra Shover. I currently serve as the Deputy Director of Administrative Services Division. I began my career here with the Department of Justice in 2014 under the Caldwell administration. I have since then been promoted to the Deputy Director role under the Landry administration. I have approximately 20 years of experience in state government human resources, and I also served on John Bell Edwards' task force for sexual harassment.
All right. As many of you may or may not be aware of, there has been some media coverage over the past several weeks regarding public records and employment issues here at the Department of Justice. Some of that coverage, at best, has been provided with hype, and at the very least, written with sensationalism. Those who repeated the information without waiting for more information followed suit. Today, we are here for 2 reasons. First, the coverage provided by some in the Louisiana media should not misrepresent or degrade the tremendous work done by this department. The people here with me today are just some of the outstanding leaders in this office who serve our great state. However, these women before me are those who are tasked with the responsibility to make recommendations as it relates to public records, employment issues, and civil litigation. Inaccurate portrayals of the work done by department employees impacts this entire office. And so I want to provide some facts. Second, we have some announcements to make today as it relates to changes within this office. Let me make one thing very clear. As a professional law firm, we do not make it a practice of discussing these types of employment-related issues within our workforce, internally or externally. We handle them normally in a professional manner. Just like every business or organization in America, we work to protect the rights of our employees, and we seek out a professional workplace. Our goal is to serve the citizens of Louisiana, irrespective of what shows up in the newspaper. However, we are working under the decision of the court as to a public records matter, and we appreciate the court's time and the judge's effort on that case. Some of what will be discussed today has been further placed in front of the public because of the advocates, legal counsel, who stepped outside of the professional bounds and the paper's choice to seek out identities, despite claiming in court that they would and could self-regulate. Apparently, that testimony was false. So we are here today, and we will proceed accordingly. At this time, I would like to turn it over to Sandra Shover, who leads our human resources issues here in the Attorney General's office.
Thank you. First and foremost, I'd like to take this opportunity to reiterate that we take every single complaint seriously within the Department of Justice. And we operate in a manner that protects the legal rights of every party involved. We believe everyone has a right to have their story heard. We treat every complaint with the importance that it deserves. Supervisors have a mandatory obligation to report inappropriate behavior contemporaneously, rather than waiting months and even years afterwards. Timely reporting is imperative. On October 19, 2020, I received information over the phone regarding Mr. McGee's use of inappropriate language within the office, and I was also informed of concerns regarding McGee's management style, specifically regarding one female employee. I met with this female employee on October 20th of 2020 and discovered that Mr. McGee's comments to her were in fact inappropriate. But more importantly, was the problems with his management style. These were of great concern. I discussed these concerns with the Chief Deputy immediately. And then we met with Mr. McGee on October 22nd. We informed Mr. McGee that he was conducting himself inappropriately and that this type of management style would not be tolerated within the Department of Justice. McGee was informed that any future incidents of this nature would result in disciplinary action up to and including his removal from employment. Approximately a month passed, and on November 20th, 2020, I received a formal written letter via email outlining the aforementioned, as well as information from events that had allegedly occurred over the course of several years prior. I notified the Chief Deputy and recommended that we contract the matter out to outside legal counsel to investigate, as I have done in other instances. We agreed that this was the best course of action and placed McGee on administrative leave pending the results of this investigation. Our office acted immediately, as we do not and have not condoned inappropriate behavior in the workplace, including allegations of sexual harassment matters. The independent outside investigation revealed that the conduct was inappropriate but not sufficiently severe to be a hostile work environment, and that the actions were outside the realm of sexual harassment. We take these issues seriously, even if some in the press have attempted to claim otherwise. I take these issues seriously, and the leadership in this department takes them seriously. However, I did determine that there were inappropriate verbal conversations, inappropriate language, and unprofessional comments regarding the appearance of employees, male and female employees. I recommended action be taken, and the Chief Deputy accepted my recommendations. Additionally, there is a media report where one individual claimed in this matter that they were not interviewed. This individual appeared in a media interview and claimed that she was not heard. This is false. I interviewed this individual on October 31st, 2020, regarding concerns that McGee's management style and prior communications with her were rude and harsh. This individual also confirmed that she brushed off the comment as rude and inappropriate, but never reported the incident to Human Resources. My work product notes from this meeting were included in the investigation and were reviewed by the independent investigator. Despite press coverage, which continues to use the phrase sexual harassment, the external investigation relied upon factual evidence and determined that we could not reach that conclusion in this matter. In fact, two items stood out in this investigation. One, as I stated earlier, the reporting employee suggested in his narrative that Mr. McGee took certain actions related to women in this office due to their gender or characteristics. This is false. Secondly, the reporting employee knew for a fact, due to his high-ranking position, that the actions taken by Mr. McGee were in line with the previously stated practice or were in line with issues already known by my office regarding these individuals. For example, in one instance, the reporting employee claimed that a female staff member was not allowed to move to a window office due to Mr. McGee's apparently being attracted to her in some way. That certainly sounds tawny. The facts surrounding the office move and why it was not allowed were reported to me by Mr. McGee at the time that this incident actually occurred, in October of 2019. The reporting employee knew that Mr. McGee had already made an office practice that due to office space constraints, that only attorneys could operate out of offices with a window. Those who were not attorneys would work within inside offices or interior cubicles. In this instance, the reporting employee decided to defy Mr. McGee's instructions for all employees and placed this female employee, who was not a practicing attorney, into a space designated for attorneys. In his letter, the reporting employee provided a narrative which did not match the stated office practice governing space for employees within this division. The reporting employee did not provide information noting that he had violated that practice and defied McGee's directive. In fact, he continued and offered that employee that space. The reporting employee's narrative defied the practice of which he was already aware. There was also no substantiating evidence that the conversation whereby Mr. McGee was apparently attracted to this individual ever took place. In another more salacious portion of the reporting letter, the reporting employee claimed a female employee was not able to get an assignment to a case due to her age and appearance. However, because the reporting employee was a high-level employee, he knew that this very same employee was already in jeopardy of being terminated from this department due to her violations of work-related policy. This employee had been warned repeatedly about her violations. However, the reporting employee left the impression in his narrative that Mr. McGee had other motives in not utilizing her in certain roles. This is false. Finally, let me state that in some of the most concerning portions of the letter, we could not find evidence that the conversations which the reporting employee described ever took place. It was literally a he said situation. In addition, some of the comments were not made to the female, and the female was likely never aware that the comment was made about her. It is also important to note that 2 of the 3 individuals mentioned in the reporting letter are no longer employed, and they did not necessarily know that they were identified in this reporting letter. Our office did not take this issue lightly. I do not take this issue lightly, and this administration does not take this issue lightly. I immediately recommended that we contract the matter out so that an independent, fair, unbiased, and impartial investigation could be conducted. In addition, our office, at the direction of the Attorney General, sought to be as transparent as possible with this case when asked about it publicly. We did not hide the fact that the information regarding inappropriate behavior was received, and we immediately acknowledged it. We provided the actual investigative memo, which I wrote to the Chief Deputy, which I intentionally wrote for his eyes only. However, we provided it, and it was released to the press when requested. It not only detailed our verifiable findings, but also the disciplinary action that I recommended for Mr. McGee. In the instances where we could substantiate inappropriate behavior, I recommended disciplinary action, and the Chief Deputy approved my recommendation. McGee was disciplined for his inappropriate language and management style. In addition, I'd like to mention that there were several factors that also led to this disciplinary action being taken. I'd like to mention that Mr. McGee is in a protected class, and he also deserves the opportunity to have his story heard. I would also like to mention, as noted in my April 7th memorandum, which summarized the incidents noted and was released to Ms. Gallo, that the reporting employee also engaged in similar conduct, and his text messages severely damaged his credibility throughout this investigation.
I would like to now address the court case. Angelique?
I'd like to address the court case, which is officially known as Landry v. Gallo. Upon receipt of public record requests by Ms. Gallo by this department, there were a number of documents produced. However, one item, the initial complaint against Mr. McGee, was in the opinion of this office not subject to production due to competing privacy interests. After counsel for Ms. Gallo threatened to file a lawsuit, again, only after counsel for Ms. Gallo threatened to file a lawsuit if the document was not produced by February 5th, 2021, did we make the decision to file a lawsuit to determine the public nature of the document. First, let me make it clear, I am the attorney who recommended that we file this lawsuit. And I did it out of professional responsibility to this office, the Department of Justice, the employees here, and because the civil service training that is mandated by every supervisor and employee in the state of Louisiana mandates confidentiality. We have a legal obligation to protect the rights of our employees. Especially in a legal office, we must be aware of constitutional protections, responsibilities, and the precedent it sets. As Sandra has already stated, our office not only provided the fact that a complaint was received, but we acknowledged an outside investigation and even presented the verified facts and discipline. I and my office determined that there could be legal issues for the Department of Justice if we went beyond those releases, and we recommended that we seek legal guidance from the court, from a judge, before we proceeded further. This office instituted that litigation to ensure transparency, as well as protecting the competing rights of the employees, witnesses, and everyone involved. The next thing I'm going to say is important. The judge in open court stated that the Attorney General followed the law to the letter. Again, let me repeat that. The judge stated the Attorney General followed the law to the letter. He said there were legitimate legal concerns as to whether the public document, it was a public document. He went on to say that the Attorney General has done everything a public official must do within the public records law. This reasoning by the judge further substantiates my recommendation to seek guidance from the court on this matter. As you know, with this court decision, we now have a judge who has determined there is a public interest in these matters. Due to the fact that there are ongoing requests of Ms. Gallo, we have continued to produce documents. And those documents include some of the working notes which Sandra in her professional human resources investigation created. Recently, a memo she wrote on those notes was released in response to another public records request. We sent a letter to Ms. Gallo's attorney expressing our dismay that he stepped outside the professional nature of that legal work and releasing an unredacted memo to a reporter, which was not intended for the public. Redactions as part of the ongoing litigation and process were not fully made. And in fact, that attorney contacted us correctly and asked if that document could be released to the reporter. And we reported no, and provided a separate document which could be released. As a result of this attorney's actions, the advocate themselves took steps in an attempt to try to identify the reporting employee.
Let me address some changes in the criminal division. But let me first say that more recently, we have received some additional disturbing information concerning another high-level member of the criminal division. This high-level employee, and it's important to remember what Sandra said earlier, had a duty and an obligation to report concerns at the moment he encountered them, not months or years after the fact. He knew that there was a policy which required him to report any inappropriate comments or actions by employees. We obtained evidence that this high-level employee, who had been with the department prior to my arrival, engaged in inappropriate and unprofessional communications that is sexist in nature, with and about DOJ employees and third parties. Additionally, I was shocked to learn that this employee, who is an attorney, was the subject of an investigation by another state agency. This other outside investigation determined the following information: that this employee impersonated a high-ranking state official. This state official who he impersonated was a high-ranking female employee of a prior governor's administration. This information should have been disclosed in his personnel file. You can imagine how shocked I was to find that it was not. This outside investigation verified all of this information. This employee created a social media account impersonating the official I spoke about, according to the investigation. This employee has now resigned during the course of the investigation into his conduct. It is important for the media to understand that supporting documents to what we have disclosed today are not being released based upon the litigious nature of this entire situation, which may be initiated by current or former employees. However, I am confident that if litigation is pursued, these documents will be made part of those proceedings. It is important for all of the hype and sensationalism that has been spread that the citizens of this state know that the men and women here work hard to serve them. Our employees are proud of the great work that they do here. Just recently, this office received an award from the United States Secret Service for our work on behalf of the state and nation. It adds to other additional awards that over the years this office has received. We work every day to protect our citizens from crime, to protect our economy and our way of life here in Louisiana. That is our mission. Those of us here today and all of the employees across this department know that it's time to move forward. Therefore, I'm announcing today a new co-director for the criminal division here at the Louisiana Department of Justice. Mr. Leon Canizaro will become the new co-director of the criminal division of the Department of Justice. Mr. Canizaro, as you know, was most recently the Orleans Parish District Attorney. He previously served as a judge in our state and served as a public defender. He has a long and distinguished legal career. Mr. Canizaro will bring his experience to bear in continuing the tough work of the criminal division. Just as I've done with any directors or leaders in this department, I choose them based on their experience and qualifications for the job at hand. In Mr. Canizera's case, he was elected as a Democrat. I'm elected as a Republican. Working as our director, I know that we can move forward, continuing to put the people of Louisiana first. The Department of Justice is here to serve the people of Louisiana and our state. And I appreciate the service of the leaders here at this table today and all the hard work that they have engaged in. And of course, I thank all of those who work at the Department of Justice doing the very same thing. It's important to recognize that we do not believe that anyone involved in this matter is considered a whistleblower. If you have an obligation based upon your position to report conduct that is a violation of our office policy, you must report that conduct as soon as possible. I am confident in the work that these women provide, as is reflected in the lack of any litigation regarding alleged victims. In the litigious nature of today's society, you would think that the type of toxic environment that the advocate is writing on or portraying, we would be stuck with a stack of litigation. And that is not the case. We take our employees' protection and the job we do here extremely seriously. Thank you. And with that, I'll take any other questions.
Attorney General Landry, you talked about an employee that some newly discovered things were alleged, the stating of a social media account and some other inappropriate, what you described as sexist in nature materials. Who was that employee? And I understand that they may not be working here anymore. Was that a mutual decision, or did you ask that person to leave your office?
Look, again, because of the litigious nature of this, we don't disclose who those employees are. We do our best to protect those employees even when they leave. And so I will not be disclosing who that employee is.
What do you, in light of the second complaint that has come forward in recent weeks, I mean, how does that change whether you think this investigation was carried out properly, and what do you say to people who think that you are, punishing whistleblowers, or you're discouraging people from coming forward even by holding press conferences like these?
I'd like to take the opportunity to answer that question. We absolutely are taking that second complaint seriously, and we are reviewing the subject matter contained within it. But I'd also like to note that the individual who wrote the complaint separated from our office in September of 2019. I'd also like to note that the individual claimed to have reported this issue to Human Resources during the last weeks of her employment. After interviewing my entire staff and those associated with Human Resources that also report to me, no one of us recall receiving her complaint or any information regarding her complaint. In addition, I'd like to make note that we had no reason to believe that this individual had any type of complaint regarding her employment with the Department of Justice, and I'd like to take an opportunity to read to you her resignation letter, which she wrote on September 9, 2019, whereby she stated, in closing, "Thank you for allowing me to serve the people of Louisiana for nearly 5 years. Your office has been a wonderful place to begin my legal career, and I will be forever grateful for the unforgettable opportunities provided to me during my time here."
Is the person that you are saying misbehaved the person that complained about Mr. McGee's behavior? And if that's the case, are you worried that that person's going to file a lawsuit saying you're retaliating against them for being the whistleblower? I understand you guys don't consider that person a whistleblower, but I'm using that as a shorthand.
Yeah, I'd like to respond to that. There is an open claim involving anticipated litigation regarding the employment matters involving this office.
But you all are not going to answer whether the person that Attorney General Landry is saying has misbehaved is the same person who made the complaint against Mr. McGee.
We're not going to provide any further information regarding the anticipated litigation.
The person who you seem to be referencing here, who did file this complaint, apparently in their resignation letter also raised several other problems with the Attorney General's office, including the way that you handled a child porn case. So Attorney General Landry, if you could speak to those issues, we'd appreciate it.
You have his resignation letter?
I'm saying
Well, you just said that you had a resignation letter. I would like to see it if you had it. I don't recall that information being part of the resignation letter.
No?
Not the one that I received, unless you received a different one. But if you'd like to share that, a resignation letter that you have with us, we'd be more than happy to discuss it. Do you have one?
I'm frustrated here that this seems to be an exercise in poking holes in the credibility of people who have tried to complain about sexual harassment in this office. And I guess I'm wondering why any employee of the Attorney General's office would feel safe or comfortable lodging any sort of complaint at this point, whenever the message that you seem to be sending today is that if you do, you're going to be subjected to a press conference about how you're not credible and about the problems in what you're reporting.
Well, Ms. Gallo, that's based upon your interpretation. We went to court to protect those employees. Exactly the reason we went to court was to ensure our employees that if you come forward, we would protect their identities. You were the one that forced us to court. And so again,
I did not force you to court. You filed a lawsuit against me. I just want to clear that up for the record.
In response to a demand that you made that you were filing a lawsuit. Let's be clear.
and so I think it's important for the media to understand that, listen, if you're not a credible source, we take these cases just like we would take criminal cases. The evidence has to support the facts, right? Or the allegations. If the allegations that are made and the evidence is not there, then there is nothing. Just because they're your source doesn't mean they're trustable.
Attorney General Landry, you, so ever since I think the allegations against former Secretary of State Tom Shedler, against Johnny Anderson, who worked in a very high up position in the governor's office, there's been a lot of interest in sexual misconduct. Senator Hewitt had the legislative auditor do a sort of a round the state government look at sexual misconduct. There was legislation passed that now requires reporting about how many incidents are in each state agency and what the consequences are and whether you found sexual misconduct. You haven't participated in those reports. You didn't participate in the audit. You didn't participate in the initial state report that was required in 2020. You did participate this year, but you sort of characterized the allegation against Mr. McGee as not having consequences, even though you docked him $20,000 in pay. So I'm wondering why you haven't participated in those things in the past.
I would like to take the opportunity to respond, as my position is directly responsible for responding to those types of inquiries from the legislative auditor, as well as responsible for compiling those annual reports. In addition, as I previously mentioned, I served on Governor John Bel Edwards' Sexual Harassment Task Force. I was a part of the task force that initiated the new law that requires that annual reporting. We absolutely did provide a report in 2020 that contained the 2019 information, which is the first year that that reporting was required in the state of Louisiana. In addition, we also compiled and submitted the report in 2021 for the 2020 year. In regards to the legislative auditor's inquiry, we were very honest and open that our agency did not track that information in the past years, as it was not required by law, and that it would be amiss for us to try to guesstimate any type of number over numerous years, over numerous administrations.
Are you not required to track that? Because every other state agency, with the exception of LSU, and I don't think you guys want to be in a category with LSU on this front. Reported information.
One of the things to me that was a litmus test as to how this office had conducted himself was based upon litigation, right? Because you mentioned Secretary Shedler, you mentioned Johnny Anderson. As far as I knew going back, we went back to look if this office had paid out any payments regarding sexual harassment claims. To my knowledge, there have been none. That's a pretty key indicator. You know, again, I mean, in today's litigious social media, open communication world, if any of those, if the environment that has been portrayed out there would exist, that would not have been the case. We're here today to basically to set the record straight, to make sure that y'all understand a good, clear picture of exactly what went on. I don't think you had anyone else do this type of conference. Why? Because there was some conduct that they certainly didn't want to regurgitate. Every time the media has asked us for information which we felt we could release, we released it. We have been about as transparent as we possibly could while respecting the confidentiality and privacy of our employees.
Mr. Shover, help me understand, if you would. I understand, and you referenced the decision by the judge, and in that court case, he talked about how your right to privacy kind of goes on a sliding scale, whereas a receptionist may have a really protected right to privacy, and someone who's at a high level, as you go higher up the ladder, your right to privacy kind of erodes a bit. You guys, certainly, and I don't know the timeline, so you can tell me, Mr. McGee's name was put out there. There's some pretty serious allegations against another high-ranking member of this office now that we've learned of. Help me understand why that person's name has not been released. And secondly, can you go back to what you were talking about the reporting employee? It seems that you were saying that he fabricated a lot of the allegations against Mr. McGee. And if so, have you been able to determine if they had some type of professional type of animosity toward each other? What would his motives have been, or did he indicate that of why he may have made up things, apparently?
It's my understanding, based upon my interpretation of the portion of the investigation which I handled. For example, there were allegations that inappropriate comments were being made, inappropriate language was being used. That was investigated independently and privately. In addition to that, there were accusations or allegations that a result of those comments occurred. For example, that jobs were withheld from females. Females may have not been assigned appropriate cases based upon different, appearance characteristics, that these females were not assigned a window office based upon their attractiveness, and that is absolutely false. Those portions of the allegations were investigated by me. They were detailed in the April 7th memorandum that I issued to the chief deputy, explaining why they were believed to have been fabricated to form a narrative.
How can you
motive,
prove
we are
something
not
like
sure
that
of.
false or
The
Excuse me.
motive we are not sure of, and I'd like to finish answering your question. In addition, I'd like to make a statement that in my 20 years of human resources experience, I have never released an employee grievance document. I've never even been asked for one. We have always released the administrative investigative report that resulted from the grievance. In this case, we did so immediately upon request. In addition, I'd like to make a note that in this case, I believe the judge ruled that this document, this grievance, or this letter from this reporting employee was a public record because of the high-ranking profile of this employee to whom was being accused or alleged.
So the employee, the new employee that has left your office, was he terminated or did he resign?
Are you referring to
The one who left yesterday.
this employee resign?
If one of the complaints is that the whistleblower didn't come forward sooner with these allegations, I mean, what does that say to people in the office who may have, want to come forward with something from years past or a couple years ago and maybe didn't feel comfortable coming forward? Are those irrelevant now?
Let me say this, and I'll let her answer. Look, I think it's important. He made a good point, and the judge recognized that as well, is that we operate on a sliding scale. So is reporting on a sliding scale, meaning those that are protected and those that have a mandatory duty to particularly report. The higher you get in a supervisory position, you have a mandatory duty to report immediately any conduct that, that they view as being a violation of our office policy. You can't wait months and months and months. You got to remember, if you're at that level, you should be reporting that immediately to HR.
And we have an office policy that's in effect under this administration that every employee is required to read and sign, and in it, it indicates that an employee who does not comply with that policy is subject to discipline and possibly termination.
Attorney General Landry, did you know before the complaint, did Mr. McGee make, I guess we'll call them off-color comments, or talk about people's appearances that he was supervising or working with to you? And do you think it's appropriate that someone's doing that? Those are the things that you have acknowledged that Mr. McGee has done.
Well, look, I think it's important for us all to recognize that we didn't in any way gloss over the conduct. We absolutely took action, and we did it in a disciplinary fashion. The amount of money that we extracted out of his paycheck was not paltry in any nature, right? This was when, and we took it extremely seriously. However, there was an inclusion of all factors when disciplining him. So it's not like we didn't discipline him. That seems to be something that some in the media may want to just gloss over. We did not. And as far as the first question, I had no knowledge of any of the complaints until they were brought to my attention as far as what they wanted to do with Mr. McGee.
Do you know that he talked around the office that way? I mean, presumably you interacted with him, so I'm asking if he talked that way to you.
Yeah, no, he didn't talk that way to me. I don't have any communication with him in that fashion.
I have another question, but just a housekeeping measure real quick. I understand the live feed has stopped. Is that? You're
Yes,
not,
it stopped right before the questions.
Let me start with that, Attorney General Landry. This, you guys as a service to the public are live streaming this event. Yet when it comes time for reporters to ask questions, the feed is stopped. Was that planned ahead of time, and if so, why?
Do what, cutting the
public is
feed?
not out. The public is not getting the opportunity to hear your questions and answer session with reporters. The live feed.
Well, I have nothing to believe that y'all wouldn't report him accurately, right?
Well, I just would.
Questions and answers.
Why the question and answer part is not continuing to be live streamed?
We actually had a good bit of technical difficulties, which definitely was on my part. Very much technical difficulties. We're going to try to get the full video out.
I actually like the live feed because when some in the media misreport things, we have an opportunity to be able to clarify them. So, yeah.
Let me ask about Mr. Canizero, certainly a high-profile name to join your team. You mentioned co-director. Can you tell us how he fits into the picture? Will he be taking McGee's old job, or was he a co-director, or will he be sharing the responsibilities?
Yeah, so when Mr. McGee resigned, we elevated Marty White, who had been a long-standing employee of the criminal division, to the directorship. Marty is actually on drop, as I appreciated, and will be leaving the office on retirement. We felt that it was necessary to bring someone in to work alongside of him in an effort to basically pass the baton. He would be leaving anyhow. And so this was an opportunity to bring someone in at the same time. And so instead of, we certainly were not going to demote Marty. He stepped up when we asked him to. We discussed this. He's going to work alongside of Marty.
How did you all reach the number for the settlement, apologies, I really didn't mean to use that word, the pay deduction for Mr. McGee, because it's a very specific number.
Answer that question for you. We took into consideration the cost of the actual contract for outside legal services for the independent investigation, which was approximately $6,498. We also factored in the amount of days in which Mr. McGee was on administrative leave, and we wanted to ensure that there was restitution to the state for that matter. I'd also like to add that due to the fact that Mr. McGee was not employed for long enough to recoup the entire amount, his annual leave payout was withheld in order to finalize the recoupment to the most amount possible.
Why did you all decide to sue Ms. Gallo personally instead of suing the advocate? I think that, I mean, this is like actually a personal curiosity. I think that struck at least the people in the media as odd.
When you sue someone, you have to make sure that you can bring the demand against the person, that you state a cause of action. She was the actual requester of the document, not the advocate, not her attorney, Scott Sternberg, not Capital City Press, Andrea Gallo. And so you have to make sure that when you bring a DEC action, that you bring it appropriately, that you state a cause of action, and that you are bringing it against the right person. And so if we would have sued the advocate over an issue that they indicated litigation was imminent over, there could have been an exception filed indicating that, you know, they were not the one that requested the document to begin with, and that was not the appropriate person. And so it was just to make sure that legally it was done procedurally correct, and it was done as a DEC action pursuant to the public records law that allows any party to go and get a declaration over a document. And it was, you know, we think we're right, but Judge, you tell us, you check us and make sure we're right. We have competing constitutional provisions here. We don't want to say something that we're not supposed to say. So Judge, you tell us if we did the right thing here.
And it's important to understand what a DEC Act actually is, because it can be confusing. Look, a DEC Act, which you have to have a party in order to instigate that type of litigation, is simply asking the court a question. We can't just go as a single party to the judge and say, Judge, we have this issue here and we'd like you to answer the question. We needed a party in order to institute that DEC Act. And it was the question that, it was the demand she was making that required us to go to the court and say, look, we're at a loss. She doesn't believe it's protected. We believe it is. And so, Your Honor, we'd like you to tell us what we need to do. And I think it's interesting because it was never reported much in the paper or by any of the media outlets, the exact language that the judge used multiple times in saying that, look, the Attorney General's office did the right thing. It was sensationalized as if we were going after Ms. Gallo. That's not in all what we did. We were actually asking permission of the court to give us some instructions. And the judge went far beyond in his comments in stating exactly that.
So I just want to clarify, do you all feel like you could not sue the advocate, or it was a better strategy to sue Ms. Gallo?
We could not sue her if we wanted to have a correct legal case. You can't just sue anybody. You have to have a right of action and a cause of action against that individual. And she wants to make it personal. It's not personal. We just needed to have this question answered.
And Julie, you know, but Julie, you know, with that in mind, y'all certainly are welcome to go see the legislature. They could change the civil code and ensure that reporters, when they ask a question, that if there's a DEC Act regarding the public records, that we sue the paper. I got no problem with that either. You know, it's not a problem. We just need a particular party.
I'm not challenging your...
No. I'm just saying if it's something that...
I'm just trying to understand.
Yeah, if it's something that irritates reporters, I can appreciate that. But if y'all would, if simply y'all go to the legislature and change the civil code so that we are directed to exactly who we need to bring into court in order to clarify these issues, I'd be supportive of that.
Attorney General Landry, the person who resigned yesterday was in charge of several high-profile cases, including several that are ongoing. How will that impact those cases?
Look, we have people that leave this office each and every day. As I just announced, we're bringing a very seasoned veteran in. I'm sure that the people next up will step in line and take care of those particular cases.
Will there be any issues, genuinely, I don't know the answer to this. Mr. Cannizzaro obviously was a DA for a long time. Is there going to be any situation in which he has to recuse himself from work with your office because you guys are gonna be doing something with a case he handled in Orleans?
I mean, look, each and every day, lawyers are faced with conflicts. As a professional law organization that we run here, we'll address potential conflicts as they arise.
And, you know, the DAs have original criminal jurisdiction, but the Attorney General gets involved daily when DAs ask for assistance or recuse themselves. We oftentimes collaborate on matters, and if there ever is an issue where a conflict arises, there is a mechanism to deal with that.
Ms. Shover, you said earlier that you had essentially proven some of these allegations false in the initial grievance. I'm wondering how exactly you're able to disprove something like this, whenever you mentioned earlier that a lot of this was essentially he said. So how do you come to that sort of determination?
I would like to clarify that I stated that there were two parts to the investigation. An outside independent investigator, a legal counsel, was hired to conduct the investigation into whether or not the inappropriate conduct occurred, whether or not inappropriate language was used, inappropriate comments were made, etc. The portion by which that I was able to analyze and investigate is what were the results of those inappropriate comments, if they in fact occurred. And based upon factual evidence that we had in the files by which the reporting employee was aware or should have been aware because of his position within the department, we were able to conclude that this was not reliable information.
Can you explain a little bit more about, so the Taylor Porter investigation purely looked into did these sorts of comments happen? And then where did you pick up the ball from that investigation?
From day one when I received on October 19th the verbal complaint via the phone, we began immediate action. We acted immediately and took this matter seriously, and we began interviewing employees. And again, I'd like to mention that over a month elapsed without incident before we received the written reporting letter of this issue.
But was it Taylor Porter or was it you who came to the conclusion that Mr. McGee's actions were not actually sexual harassment? You mentioned, they might have been off color or inappropriate, but they weren't sexual harassment. So whose determination was that?
The determination was made by the outside legal counsel.
Attorney General Landry, I know that you and Mr. McGee go way back, I think back to your college days, and you worked together in the past. Certainly a big hire when you brought him on, and likely disappointing for you that it's ended the way it has. In the future, should the situation arise, would you consider hiring him back for a position to work underneath you?
Look, I've known Pat for quite some time. He worked in a distinguished position at the district attorney's office in Lafayette and with a number of firms. I think that I'm hopeful that he understood the results of what came out of the investigation. Again, like all of us, we hope that when we make mistakes, we're able to rectify them. And so whether I would hire him again or not, I guess would be a question of his ability to be able to rectify whatever he did. We just went through a whole session a couple of years ago in making sure that we didn't penalize people for their criminal records in hiring opportunities, meaning that we're able to forgive people. And so, again, I would leave that to whether or not it would come up. I don't know.
I also want to clarify, and I'm going to use an example, and I don't mean to compare Mr. McGee to Johnny Anderson, that's just what I'm most familiar with. So, Southern investigated Mr. Anderson many years ago about sexual harassment, and when Mr. Anderson was talking to me about it, he would be like, I was exonerated. Well, the way I interpreted what happened was, they just couldn't confirm that the sexual harassment took place. The people involved would not talk about it, right? In this case, are you saying that you couldn't confirm that Mr. McGee made these comments because he wouldn't confirm them and they took place between two people? Or that you really believe these comments were never made and they were wholesale made up by this other person?
As was stated in the disciplinary letter issued to Mr. McGee, it is clear that he did engage in inappropriate behavior, and he did engage in inappropriate language, and he did, in fact, make inappropriate comments. And that was detailed and outlined in his disciplinary letter that was, in fact, released to the media.
Right, but the things that you're saying that I'll call them a whistleblower, just to like clarify, person X, that person said that turned out to be things that you aren't sure are true. Is that because Mr. McGee said they aren't true, or is there other reason to believe that they're not true?
I would like to make it clear that Mr. McGee said in some instances, these were he said situations. In addition, the reporting employee also relied upon hearsay information from other parties, some of which had not been employed for numerous years.
Okay, so in some situations, the person X said, McGee said this, Mr. McGee said he did not say that, and you all were not able to figure out if that conversation took place.
Again, the outside legal counsel handled that portion of the investigative matter, so I'm limited by what I can say in regards to that. But again, they did handle that portion of the complaint.
Why didn't that outside legal counsel portion of the investigation go deeper? Their billing records look like they only interviewed 2 employees plus Mr. McGee. Why weren't former employees interviewed? Why wasn't the entire office interviewed?
In that particular letter of information that was sent to me, there were 5 scenarios listed. I would like it to make it clear that there were not 5 separate employees mentioned in that letter, some of which were involving the same individuals in more than one scenario. In addition, I'd like to note, as stated earlier, that this investigation went back for several years. Several investigations have been done previously regarding some of these same individuals, and that information was on file with my office, and it was in fact turned over to the outside legal counsel for review and consideration. In fact, as I mentioned earlier, the one individual who mistakenly went to the media and said that her story was not heard was in fact interviewed by me, and that statement was in fact turned over to the outside legal counsel for review and consideration in this matter.
And I'd like to add that those documents have been produced to you, and I'll say the last 3 digits of those documents, 167, 168, 169, 170, 291, 292, 317, 318, 199, 200, 201, 202, 203, 293, 319, 253, 254, and 255, and I'm referring to the Bates numbers for the documents that were produced in connection with litigation. I may have missed something, but those include some of Sandra's notes, but they were all part of Vicki Crochet's file.
So the notes that were included from you, Ms. Shover, in that document, those were your notes from your own internal, I don't know if investigation, review in the past that later went to Ms. Crochet when she did her own investigation? That's what those are? Okay.
Ladies and gentlemen, we've been here for just over an hour, I believe. I think we've answered a number of questions for at this time. In respect of everyone's time and the staff here, we're going to cut the press conference at this point. If there's any follow-up, feel free to reach out to our office. Thank you.
Thank you.